Good morning, everybody. I'm Mary Charles, Wolseley's Executive Director, and it's my pleasure to welcome you to the third session of our 2022 Annual Law Conference. The topic this morning is parenting arrangements. First, we'd like to acknowledge that CLIA's office is located on Treaty 1 territory, the traditional gathering place of the Anishinaabe, Cree, Oji-Cree, Dakota, and Dene people, and is the traditional homeland of the Métis people. Winnipeg's water is sourced from Shoal Lake First Nation. We acknowledge that much harm was done in the past and dedicate ourselves to move forward in the spirit of reconciliation. Now, a little bit about our presenter. Leah Klassen is a partner at Wolseley Law, a firm that's dedicated to doing law differently with the goal of increasing access to justice through unbundled services, legal coaching, and block fees. Leah currently practices in the areas of family law, wills, and real estate. Leah serves on the board of the Regenesis Center for Recovery as a way to give back to the community. Outside the office, Leah enjoys going on camping trips, preferably that require long highway drives, and reading British crime novels and trying out new recipes. So I'll turn it over to Leah. Thank you.
Hello, everybody. Thank you for joining us today. Mary, I'm not certain a way for me to see everybody.
Oh, you actually can't. It's a webinar, sorry.
Oh, that's fine. Okay. So that's all right. So if people are raising your hands, I cannot see you. But please, if you have questions throughout my presentation, please put them into the chat. I will try to answer them throughout, and Mary will be helping me catch the questions that I might not receive. And if I have questions at the end, I'll also reserve some time for questions at the end for you folks as well. So our presentation today is on parenting issues. So the law has changed a bit in recent years, specifically in relating to terminology and just in terms of some of the basic issues that can arise with different parenting arrangements as folks are separating, as they're divorcing, and there's children involved. There are so many different ways to approach co-parenting as they transition from sort of one family to two families. I'm sure you folks in your professions see this a lot and see the different ways that this can go. But I'm going to talk a bit about the law in these aspects, and hopefully you find it useful. So to start off, we're going to talk about some of these issues when relationships end. So obviously, when it comes to children, we need to talk about custody, care and control, and access. And these are the terms that are used under the provincial legislation. Those are sort of the traditional terms that we were always kind of used to hearing, that of custody and care and control. What has happened recently is that the federal legislation, the Divorce Act, has changed the terminology, and we now use the terminology instead of custody, we use parenting, the term parenting time, instead of care and control. We use the term of decision-making responsibility. And we've changed these terms, and the federal government has decided to change this terminology. So it's sort of less possessive feeling when it comes to the children. The goal is always to do what is in the best interests of the children. That's sort of the ultimate test. And so as part of it, we want to make sure the children's interests are being taken into account and that the terminology reflects that. Now, the provincial legislation has not yet caught up to the federal legislation. The difference between the two is that when a couple was married, the legislation that's used is the Divorce Act, and that's the federal legislation. If it was a common law couple or a couple who never was married or together, but do have a child together, then that's when the provincial legislation is used. There are changes underway to change the provincial legislation to reflect the same terminology as the Divorce Act. That just has not gone through yet. So unfortunately, in the meantime, we're kind of stuck with these two different sets of terminology, but I'll try and clarify as much as I go forward. This change happened as of March 1st, 2021. So it's been about a year that we've been working with these new changes, and we started to see this kind of come forward in our parenting plans, in the court orders that we are seeing. So there are things that you as professionals in your fields may have now started seeing these terms in the agreements and the orders that you're seeing come through. So let's go through both of the pieces of legislation a bit. So the Family Maintenance Act is what determines and talks about custody here in Manitoba. The custody means the care and control of a child by a parent of that child. Whoever has custody includes the issues of decision-making and care and control. The court will always consider, as I mentioned before, the best interest of the child when they are determining who should have custody of that child. Some examples of what they will consider when they are determining what is in the best interest of a child is they will think about the nature, quality, and stability of the relationship between the child and each parent, between the child and other significant individuals in that child's life. They want to consider the child's physical, psychological, educational, social, moral, and emotional needs. They understand that children need stability. They're going to consider that when they're determining who will have custody of the child. Something that is extremely important for them to consider is the impact of any domestic violence in the family, and the safety of the child and other family and household members who may be having care of the child. They, of course, want to consider the child's general well-being, the appropriateness of who should have custody in terms of practical instances where parents live in relation to schools, that sort of thing. The proposed plan of care for the child that each parent who is seeking custody has, the proposed plan that they have. It's important to consider any special needs that the child has, whether medical or educational, to make sure that they still have access to that care. It's important to consider the history of the care arrangements of that child, who traditionally has been doing that role for the child in order to keep things as stable as possible. The effect of the effect on the child of any disruption in the child's sense of continuity, as well as the views and preferences of the child. So, especially the older a child is, the more likely a court would be to consider their wishes in terms of who is to have custody of the child. And of course, this also applies to not just the provincial legislation, but also the federal legislation. So not just custody, but also decision-making, responsibility, and parenting time. So one of the ways that a court can determine what the wishes are of a child is something called the Voice of the Child report. And this is something that we as family law practitioners have been seeing kind of more of recently, is utilizing these. So there are certain professionals, often child psychologists or social workers, who are trained in being able to take a Voice of the Child report. They will meet with the child and ask a series of questions and talk to them and get down on their level and determine what it is that the child would like when it comes to parenting time with their family. And this report would then be used either in an agreement if the couple is negotiating a separation agreement with a parenting plan, or it could be used by the judge to consider how custody should be ordered. So that is something that we're seeing more of.
Sorry, Leah, to interrupt you. The slides aren't advancing.
Oh,
so
okay.
You were doing so well, though. So if you can't get them to advance, we can always send out the PowerPoint at some later date. Oh, there we go.
Is that working?
That's working. Sorry.
Nope, that's fine. I think I was just not, I just have to click a few things to make it work, but it's fine. Thank you.
Sorry,
Thank
everybody.
you very much. That is
Sorry,
all good.
sorry,
Thank you for letting me know. Are there any questions that have popped up yet, Mary?
No, aside from the slide,
Okay,
slides,
perfect.
we're good.
Perfect. Awesome. Thank you very much. Okay. So now that we're on the right track with the slides, I'm going to talk about the different types of custody. Again, we're using the term custody, so we're discussing provincial legislation here. There are 4 different kinds of custody, and we will discuss each of these. Remember, provincial legislation is used when the parents of the child were not married. We'll start with sole custody. So sole custody is something that I'm sure is a term that you've all heard. There is a presumption of sole custody if the parents of the child have not lived together after the child is born. The parent who the child lives with is then presumed to have sole custody of that child. This is really the only time when custody is presumed in any case. The parent that has sole custody has the authority to make decisions for the child, and they have physical custody of the child. So the child is in their care. The other parent will often have access, periods of care and control, periods of access with the child. That's something that typically happens, and either by agreement or by a court order. So courts will often specify when this access is to occur and under what conditions, if there are any conditions. There are times when access might need to be supervised if the courts are concerned about the safety of the children. For example, if there are concerns about abuse. So again, this can be something the court orders or can be done by way of agreement. A way to supervise access is to use access agencies. So there are several agencies throughout the city that have as their specific task to supervise access between parents and children. Another way to do it is by using a third party that is agreed to by both parents to supervise. So this can often be a family member or a trusted friend or a professional that they all agree is someone who would be able to supervise that access. Regardless of which parent has custody of the child, the other parent always has the right to information about the child. And this is set out in the Family Maintenance Act that, unless a court otherwise orders, which always can be the case, the non-custodial parent always retains the same right as the parent who has custody to receive school records, medical records, psychological, dental, and any other reports that affect the child. That's always something that they have a right to when it comes to sole custody. So moving on now to joint custody. So both parents are entitled to joint custody of their child if they have lived together after the child is born. So they can both either apply to the court or request that they have some sort of joint custody arrangement. Often in these situations, one party has primary care and control of the child or children, and the other parent has care and control as may be agreed to, or as ordered with specific periods of access. So a really traditional example of this is that one parent has primary care and control, the other parent has periods of care and control on, say, a Wednesday overnight and alternate weekends. That's sort of a really traditional type of situation that we've seen often in the past. But the one parent who has the majority of the time with the child will be the one to make final decisions for the child. This can also be a shared responsibility. So even in a joint custody situation, what may occur is that each parent has a different responsibility when it comes to decision making. So one may have final decision making authority over health decisions, for example, and the other parent might have final decision making over education decisions. So that's sort of an example of that split kind of final decision making authority. This will often occur sort of as a creative solution if there are parents who are both very involved in the child's life and have a lot of input, but they really can't communicate between each other, but they still want to have the ability to make those decisions for their child. It can also occur in situations where perhaps one parent is far more involved in one area of the child's life and it's just significantly more important to them. And this again is a creative solution to be able to have the parents share that responsibility. As we are talking about shared responsibility, let's begin talking about shared custody, which is the third type of custody that can happen under the Family Maintenance Act. So in this situation, the parents share the decision-making and the care and control. In this type of arrangement, each parent will have the child in their care at least 40% of the time. So a really traditional situation here is a 2-2-3 schedule where one parent has the child 2 days, the next parent has the child 2 days, and then 3 days, and then they sort of rotate through, or a week on, week off type of scenario would be another very, very common shared custody arrangement. In this arrangement, both parents often have equal decision-making responsibility. They will need to communicate with one another, and they will need to both decide on medical decisions, on healthcare decisions, on educational decisions. And typically, if there's a situation like this, they are sort of able to have that communication between each other and do that. Split custody is the fourth type of custody that we're going to talk about here. So this is kind of a unique one where if there is more than one child, one parent will have primary custody of one child and the other parent will have primary custody of the other child. So it's split. At this point, obviously the other parent will have periods of care and control with the child that they do not have custody of. This is not as typical of a scenario. We don't see this quite as often, but it is something that comes up and is completely legitimate under the Family Maintenance Act as an option for parents if this is what works for them and if that is what is in the best interests of the child or children as well. So before I move on a bit to the Divorce Act, do we have any questions at all about what I've talked about so far? I'll just pause slightly in case there's any questions. Otherwise, I will move on.
There is a question in the Q&A.
Okay, I'm just not sure how to access that, Mary. I'm not sure if I can while I'm in presenter mode.
Okay. Do you want me just to read the question?
Yes, please.
Okay. In what scenario is split custody most beneficial for the child?
That's a great question. So what I would say is, as family lawyers, we see a lot of different unique situations. For example, a split custody arrangement might be beneficial to a child if one parent perhaps has a spot in the country and one parent prefers to live in the city. And if one child, has a lot of friends at the country house or has a lot of activities in the city, and they would like to maintain those activities and maintain those friends, a split custody arrangement might be something that's beneficial to those children. That's something that I've certainly seen in the past. So that's one example of when that might be beneficial. Great question. So moving on to the Divorce Act. So at this point, we're talking about the federal legislation, the one that changed last year, and talking about parenting arrangements under that legislation. So we have different terminology now. Instead of custody, we're using parenting time, we're using decision-making responsibility. And then I want to talk about parenting orders, parenting plans, and contact orders. I think these are sort of important things to discuss. So parenting time is the time that a child is in the care of a parent or someone acting in the role of a parent. The child does not have to physically be with the parent throughout this entire time. So for example, the time that a child spends in school or in daycare is still considered parenting time. So when we were discussing before, that shared parenting time, that's where the child is with the parent at least 40% of the time. School and daycare is included in that 40%. Parenting time might be set out in a schedule, or if the parents are able to communicate relatively effectively with one another, it might be more flexible in the sense that they will ask the other and discuss, weekly or even daily, what parenting time would work for each of them. Decision-making responsibility is a parent's ability to make certain important decisions about a child's well-being. So this includes making decisions about the child's health, education, religion, language, and extracurricular activities that play a significant role in the child's life. As we talked about before, decision-making responsibility might be split between parents, or one parent might have the final say when making these decisions for the child, or they might share this responsibility. So for all of them, both parents will have a say. A parenting order is an order made by the court setting out a parenting arrangement. This order will include the amount of parenting time each parent is entitled to, and whether decision-making responsibility will be shared, or if one parent will have the final say. Once a parenting order is made, both parents must follow it until it is either varied, changed, or removed. So this is when parents go to court and the parenting arrangements are codified in an order. Now, this doesn't always happen. It sometimes happens in a parenting plan, which I will discuss in the next slide. But first, let's move on to contact orders. So a contact order is a court order that allows somebody other than a parent, such as extended family members, grandparents, aunts, uncles, etc., to be able to spend time with the child outside of parenting time. So courts are not likely to grant a contact order if it is reasonable for the child to have contact with that person during parenting time. So for example, if grandparents can visit with the child while one of the parents is exercising their parenting time, the court is probably not going to grant a contact order for the grandparents. However, the court may grant a contact order for grandparents if, for example, they are estranged from the parents of the child, but still it's really important for the child to have contact with their grandparents separately, but it can't be facilitated through the parent. So a contact order might occur in that situation. So again, both of these are orders that are provided by the court that would then need to be varied or changed if the situation changes. Part of the change in the legislation was with a goal to hopefully reducing the amount of families who are actually going to court to get these kind of orders. So the goal kind of has been in the last couple of years to move parents and families towards resolution outside of court, which often results in really comprehensive separation agreements, which can happen for both couples who were married and who were not married, that really outline everything that a court order would have outlined, but without the need to go to court. And then they can simply just go to court to get a divorce if needed. So we are seeing a lot more of these really comprehensive separation agreements. And often, as a part of a separation agreement, what we will see is a parenting plan. So parenting plans can be prepared by co-parents, and it's often with the assistance of parenting coaches. So I have been doing a fair amount of these where I refer my clients, and the lawyer on the other side of a matter will also refer their client to a parenting coach. And this is often a social worker or a therapist who is trained in this work, who's trained in parenting coaching. And this is something that we've been trying to do a lot more of. So it's a very detailed plan. It's then often incorporated into the separation agreement with the other issues that are needing to be dealt with, like support and property. So this plan will put in the details of access, the details of decision-making responsibility, and just sort of the everyday specifics of what co-parenting will look like. And I'm going to go through some examples of the things that a parenting plan will often discuss. An order will often discuss these things as well, but it's a bit more limited in the detail and the creativity that can be put in order because there's specific wording that needs to be used. In a parenting plan, we're not as limited, so we can be a bit more creative, which can often be really helpful for the families that we're trying to help and be in the best interests of the children as well. So a parenting plan will often discuss travel. So for example, who is holding the passports? How much detail and how much notice is one parent going to be giving to the other when they want to travel? Is that just for out of province travel, or is it just for out of the country travel, or is it for any kind of travel outside of the province? We go through these kind of details. Another aspect is childcare and first right of refusal. So if a child is sick, or if a parent is sick and maybe can't do their parenting time, who are they going to call? Are they going to call each other first? And if the other parent cannot do it, then is it daycare? Is it a grandparent? Who is the one who is the secondary caregiver if the parent is not able to care for the child on their given day? Next would be decisions. What is a dispute resolution process if parents are not able to come to a agreed upon decision for the child, because that certainly happens. We see that a fair amount. So typically it's understood and often laid out that day-to-day decisions, what snack is the kid having? What shoes are they wearing that day? These of course are decisions that are made by the parent who has the parenting time that day. However, any major decisions need to be discussed between both parents, and typically there'll be a mechanism for how that will happen in a parenting plan. If there is an impasse, and if both parents are not able to come to a resolution, we need to have some sort of dispute resolution process. Usually what we put into these kinds of agreements is that we will say that they will go to a parenting coach if they really cannot come to an agreement about a major decision. And I have heard anecdotally that has worked for many parents who have these kinds of detailed plans, especially if they've already used a parenting coach to get to the detail in this plan. The other thing that's laid out is education. Who's going to be the school contact person? Is it both? Are both parents going to be involved in parent-teacher conferences? Are both parents going to be involved in school events? How is homework going to be dealt with? Are we going to have supports like counseling and tutoring? Are both parents going to be involved with that, or are we fine with one parent taking charge of that? We detail those things there as well. Same thing with medical dental. Who's handling the appointments? Who is keeping the children's health card? Who is handling the medications for the child, if that's relevant? Who is the contact person? Who is the one booking the appointments? Those kinds of things. How are emergencies being dealt with, right? So, is there a protocol for, if there's an emergency, we're going to call the other parent, within an hour of knowing that this has happened, right? Those kinds of things are laid out there as well. Activities and lessons, how is that agreed upon? What activities are the children going to be in? Is there a limit? And how are the parents going to be involved, right? Maybe one parent is really cares about soccer, was a soccer star in their youth, and they want to be the one to coach the children's soccer team, right? That's really important to them. So maybe that's outlined there, right? This, parent A, they're the one in charge of soccer, and maybe parent B does the piano lessons, right? ideally that's something that we would lay out there. Religion, is there a specific religion that is important to the parents? And if so, how is that going to be dealt with when it comes to the parents? Speaking with the kids about that, right? How is that impacted in their day-to-day life? Mobility and parents moving. I'm going to talk a little bit more in detail about that later, but it would often be discussed in a parenting plan as well. We think it's in the child's best interest to remain in this school district. So both parents agree that they're not going to move out of the school district unless it's agreed upon by both parents. Often what is important to be discussed as well is there a new partner involved? Or if there is a new partner or a third party involved, how is that person going to be introduced to the children? At what point in the relationship is that going to happen? We're often will have wording there that states that, the parents are never going to require that the children call a new partner mom or dad, right? They're not going to encourage that or require that. So that's a lot of times language that's included in this kind of plan. Safety, things like alcohol, marijuana, how are we as parents approaching that? That's laid out there. And then often different special occasions, right? Who's getting Christmas? Who's getting kids' birthdays? Who's getting Mother's, Father's Day? Is Halloween really important? How are we sharing that? So these are the types of things that are often dealt with in parenting plans, and I've seen that work really well, especially for parents who can have the ability to co-parent with one another.
Leah, can I just stop you for 1 second?
Absolutely.
There's a couple of questions I thought maybe we could deal with.
Great. Absolutely. Yes.
Okay, sorry. The first one is, actually there's 3 now. At what age is it appropriate to start a toddler on a 2-2-3 schedule?
That's a great question. There's no, right answer to that, because for, every toddler might be a little bit different. However, traditionally, kind of what I have seen is around, the 2 to 3 year mark. Often it will be, if there's breastfeeding involved, that's sort of a factor that needs to be taken into consideration as well. But often between the 2 to 3 year old mark, as soon as they're onto solid foods and don't require, being around one parent for a significant length of time, you can start that kind of process.
Okay. Second question, what legislation changed last year?
The Divorce Act changed last year. So that is, in March of 2021, the Divorce Act changed in a couple of different ways, but specifically what's relevant here for us is that it changed the terminology from custody to parenting time and decision-making responsibility. And it's changed in a couple other ways as well, such as mobility, which we're going to come to in a few slides.
Okay, and last question, unless people have other questions, how should costs for sports, music lessons, etc., be shared?
Great question. And the answer, as every good lawyer's answer is it depends. It very, very much depends on the situation between the parents. So typically, in a shared care arrangement where each parent has at least 40% of time with the kids, those are often split equally between the parents. However, if there's a large discrepancy in the parent's income, that might not be practical, right? Especially if one parent has, finds it really important that the kids be in a lot of activities, but they're the higher income earner, it may not be practical or responsible for the lower income earning parent to share equally in all of the activities that the other parent wants the kids to be in. So this is often a discussion that needs to happen as part of the separation agreement or court order, where we determine, what's practical. Is there going to be a cap on that, right? Maybe they share equally up to a certain amount of $1,000 a year. And then after that point, then the higher income earning parent, maybe they pay for the rest of it if they really want their kids to be in certain activities. So we can be a little bit creative. In general, a lot of times it's split equally, or it can also be split proportionally according to income, which often occurs in a joint custody situation or joint parenting. All right. So if there is no other questions about that, then I will move on a bit.
Or I spoke too soon. One more question.
Oh, no, that's good.
How do you advise a parent wanting to make a will? I'm not sure.
That's a big, that might be a webinar in and of itself. But first of all, I always advise my clients, if they're going through a divorce or split, that they should be making a will. And the main thing to consider is who you are naming as a guardian for your child, because it typically is the other parent, right? Regardless of whether or not you are split up, it would typically be the other parent, and you'd want to make sure that that's laid out in your will. There's a lot of other factors that go into it. I don't think I can go into them all here, but perhaps Mary and I can talk about a webinar on that topic at some point in the future. But great question. So moving on now to that Divorce Act. So to that legislation that has changed. Parents who are, so under the Divorce Act, parents who are separated or divorced are entitled to as much parenting time with their child as is in their child's best interests. There is no presumption that the parent should have equal time with the kids. That is something that changed in the Divorce Act last year. So we're not presuming both parents should always have equal time with the kids, and then we move backwards from there. We are only saying whatever is in the child's best interests with respect to time with their parents. And we use a lot of factors, as we spoke about before, to kind of determine what that is. And we're going to talk a little bit about them here. In some cases, it might be in the child's best interest to not see one of their parents, or to only see them under supervision, especially in situations where there has been family violence. And this is one way that, this legislation has changed to sort of recognize the fact that when there's family violence, it is not necessarily in the child's best interest to see a parent that's perpetuating that violence. When making a parenting order, the court must focus only on what is in the best interest of the child. So they are going to look at the child's needs. They are going to look at the nature of the child's relationship with each parent. They will look at the child's history of care. They will look at the willingness and ability of each parent to maintain the child's relationship with the other parent, and if that's appropriate. They will look at the child's preferences if they are known, and again, they can use the Voice of the Child report to determine that. They will consider the child's cultural, linguistic, religious, and spiritual upbringing. They will consider the willingness and ability of each parent to cooperate with the other. They will also consider any history of violence in the family. And something that they've added in as well in this change is they'll consider any existing court order or proceeding that is relevant to the child's well-being. So as part of, for example, new forms that have come into play, the one thing that we as lawyers have to do is we have to let the court know if there's a protection order in place, if there's any criminal matter that is being considered between any of the parties, and also if there's any civil matter, are they suing each other for any reason? Is there a small claim? We have to let the judge know if there's any other type of proceedings. That wasn't something that we were required to do before, and we are now, so that the judge will always have a full and complete picture of what is happening when they're making a family order. They want to make sure that they have the full picture. So as you may have noticed, one of the big reasons why the Divorce Act was changed is to consider more fully the issue of family violence. And I know there has been a webinar on that already as part of the law conference, which is a really important topic and something that we as family lawyers have to deal with and consider, on a daily basis. The Divorce Act definition of family violence has been expanded. That's part of what the change was, is the expansion of that definition. So it means any conduct, whether or not that conduct constitutes a criminal offense. So it does not have to be a criminal offense for it to be considered family violence, by a family member towards another family member that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes any other family member to fear for their own safety or that of another person. In the case of a child, that is even just the indirect exposure to such conduct. So this conduct does not have to happen directly to a child for them to be considered exposed to family violence, right? If it's happening between intimate partners and the child is around, there's an understanding now that perhaps wasn't there before, that this affects a child deeply. Just, it still affects the child when it's not necessarily happening to the child directly. So there has been this expansion of this definition in the Divorce Act, which I think is incredibly important, and the courts now have to consider that when they are making a court order in the best interests of the child. So the courts will take this list of factors to help assess the seriousness of the violence and how it could affect future parenting. And they will use this to decide what parenting arrangements will be in the child's best interests. And they, again, will take into consideration any other court proceedings, so any other criminal or civil proceedings, or restraining order, protection order, any of those things that they will need to take into consideration when making a court order with respect to the child. Okay. So, Family Maintenance Act, in terms of access to information of each parent, to the information about the child. I think we've kind of touched on this already, but both parents are generally entitled to be able to access this information under the provincial legislation as well. So parents will want to ensure that third parties like daycares, schools, doctor's offices, dentist's offices, they have every parent's contact information, and places like schools should know that, both, unless there is a court order that specifies otherwise, parents always have the right to access to that information about their children. That doesn't mean that they can make decisions about the child or for the child, but they do have access to that information about the child. Just take a water break. So, under the Divorce Act, the entitlement to information is specified as this: unless the court orders otherwise, any person to whom parenting time or decision-making responsibility has been allocated to is entitled to request from another person that has parenting time or decision-making responsibility any information, and to be given that information about the child, right? So it's a little bit different. So you have the ability to access information about the child if you have been given any parenting time. So if there's a situation where a parent has no parenting time with the child that has not been deemed to be in the child's best interests, they also do not necessarily have access to information about that child. So unless there's any questions of the access to information issue, I will move on to mobility issues.
We do have a couple of questions.
Absolutely.
The first one, basically, at what age can a voice of the child report be done?
That's a great question. And this is kind of a moving target. And some professionals, they specialize in younger children. And, I just did a CPD a little while ago, a few months ago, where, they're doing this with children, as young as 3 or 4. Is it quite as detailed? No. But there are professionals who are sort of specialized in younger children and their development. They really get down on their level to be able to make this kind of report. And it's not, something that is automatically followed necessarily, but it is used. So we're starting to see this happen with children who are younger and younger.
Okay, second question, would one parent speaking negatively about the other parent to the child be considered under psychological abuse of the child?
Potentially. It depends on the situation, right? So what you're discussing is perhaps on the spectrum of what's known as parental alienation, right? So if one parent is speaking negatively about the other parent to the child, and as a result is alienating that child from the parent, that's something that, number one, should be dealt with quite quickly and with therapeutic support. So a therapist or a social worker should be getting involved, as quickly as possible to try and deal with that. And that absolutely is a factor. If it can be proved to be the case, that would be something that, a court would take into consideration when they're determining what is in the best interest of the child.
Okay, we've got a bunch more questions now.
Good.
Okay, I've noticed an increase in grandparents as the primary caregivers. Can grandparents apply for sole custody?
So when it comes to grandparents, typically there is a guardianship order that is made. They can apply for sole custody. I think that there is, you're right, an increase in that occurring. Yes, it can happen.
Okay, can you give the parenting arrangement that is done with days? We can ask for clarification.
So yeah, I'm not sure I quite understand the question.
Okay, maybe if you could, the person asking the question could provide a supplemental question that would clarify what you mean.
Yes, please.
In the meantime, okay, and they have. Can you give the parenting arrangement that is done with the court, like the days 2-3 or 5-5?
So you can do kind of whatever you want, right? So either the court can order something that they deem is correct, or in an agreement, two parents can come to an agreement on any type of arrangement. So it can be, parent A gets Monday, Wednesday, Fridays. It could be week on, week off. It could be 5-5. It could be 2-2-3. It doesn't have to be one of those. Those are just some common options. But you can agree to anything, and the court can order anything. I'm not sure if that answers the question, but if it doesn't, please send a clarifying or a follow-up.
Right. Okay. My organization, this is from the attendee, often sees a situation where only the mother is on the birth registration, but the children are in the father's care, and now he needs to get their birth certificate. What would he need to do to be eligible to request the birth certificate?
So he would need to be declared a parent. So there's such thing as a declaration of parentage that can be done. So if the mother agrees that he is in fact a parent, then that can be done relatively simply. But through a petition, so there's a court form that is either a petition or a petition for divorce. So again, either if the parents were married or not. However, if the father is not on the birth certificate, probably they were not married. So you would file, so that person would file a petition, and one of the boxes to check is a declaration of parentage. And once he is declared a parent, he can in fact go on to the birth certificate and can apply for a change to the birth certificate.
Okay, and what rights do grandparents have?
So that is to be determined by agreement or by a court. So we talked a bit before about contact orders. And this is an order that a court can give if it's deemed to be in the child's best interests to have contact with a grandparent. So a grandparent does not have an automatic right to necessarily have access to a child, right? Again, we have to go back to that common phrase of what is in the best interest of the child. So grandparents do not, in the same way that a parent has, even have access to information about a child, right? That right doesn't exist legislatively for a grandparent. So instead, if a grandparent is not getting access to a child, then either that would need to be done, set out in an agreement with the parents, or they would need to go to court for a contact order and basically show the court why it's in the child's best interest that they have contact with the grandchild.
Okay, that's all the questions. And now that I've said that, another one will pop in, but no so far.
Wonderful. Perfect. Great questions. Thank you for sending questions, everybody. I like when there's questions and engagement. So that's great. Good questions. So moving on a bit to now another topic, which is that of mobility issues. So the ability to move with a child, which again is a bit different between the provincial legislation and the federal legislation. So under the provincial legislation, parents generally should not relocate the child without the consent of the other parent. This is true unless there is a court order that specifically allows that parent to move the children, or an agreement, right? So either a court order or an agreement that says, yes, we've contemplated a move is fine. Maybe we expected this, maybe we've already talked about this, or maybe they have sole custody and have in their order, you have the ability to move with the child. But if that does not exist, parent should not move. And when we talk about relocation, we are talking about significant relocation, right? It's not from, street A in Winnipeg to, 3 streets over. It's, moving 6 hours north. It's moving to a different province or out of the country, right? Specifically, where a parent has specific access rights that are outlined in an order or agreement, and if it isn't an order and the other parent moves away with the child, then the moving parent might be found in contempt of that court order because it's essentially stopping the other parent from having those same periods of access that they have in the order. So that's important to consider. There is a case that we as family lawyers have always used to determine whether or not a parent can move with a child. And again, this is if the couple was not married and it's under the provincial jurisdiction. So if a parent goes to court and says, okay, judge, I would like to move with this child, and this is why, the judge has to consider these things. They have to consider what is the existing custody arrangement and relationship between the child and the custodial parent, the one who has custody. And what is the existing access arrangement and the relationship between the child and the parent who has access, so the parent who does not have custody. What is the desirability of maximizing contact between the child and both parents? What does the child want? What is the parent's reason for moving? right? We want to, often the judge will only consider it if it's in the exceptional case where it is relevant to the parent's ability to meet the needs of that child, right? Have they lost their job and they have a great job opportunity, the next province over? And that's something that then the judge would seriously want to consider. What they also need to consider, what is the disruption to the child going to be? Do they have a lot of friends and a support network here that will be disruptive to them, or not? What is there going to be a change to their community life that will be incredibly disruptive to them? So those are the types of things that the case of Gordon and Gertz laid out as the factors that a judge would consider if a request is made to be able to move with the child. Of course, there's also the criminal aspect of this to consider. If a parent moves without confirmation from the court that they can do this, they could be charged with abduction in contravention of a custody order. So that's important for any parent to think about. So now moving on to how it occurs under the Divorce Act, which is another way that has the Divorce Act changed relatively drastically. So the Divorce Act makes a clear distinction between moves and relocations. A relocation is where the parenting schedule will no longer work. So that sort of is that distinction I made earlier. It's like a move, maybe they move an hour outside of the city, but they're prepared to do the driving, that the parenting plan that's in place is still going to work. That's a move. A relocation is, they're moving 3 provinces away, and that's the current schedule is never going to be able to continue. So a parent who is just planning to move must give notice whether they're planning to move with or without the child, right? And they need to give that information to any person with parenting responsibilities. So they just need to provide the date of the move, the new address, and the contact information. So they do need to do that. For a relocation, however, the parent has really specific obligations on how they need to proceed. So they must give notice at least 60 days before the relocation, and they have to include the following. And they need to provide this in a specific form. There is a specific notice of relocation form that they need to fill out, and they need to provide this to the other parent. This includes the date of the move, the new address, contact information, how the parenting schedule is going to change, and how they intend to promote an ongoing relationship with the child, right? And then again, sometimes this can be dealt with by way of agreement, or it might require a court appearance. Now, if the only exception to providing this notice in this notice of relocation form is if the parent is afraid for their safety or afraid for their child's safety. And in that case, they can ask the court to change the notice rules, but they will need to request that of the court. Otherwise, they will provide this notice. So once this notice of relocation form has been provided, the other parent then has 30 days to object to that. They can either provide specific details about their objection in their own form, the objection to relocation form, or they can apply to the court to stop the relocation. So again, it can happen one of those 2 ways. If the other person objects, so if the other parent objects in either of those 2 ways, no, I do not want this relocation to happen, then the relocation cannot happen until a judge decides it's in the child's best interests. So to decide this, the court then may look at, again, the same kinds of factors that we've looked at before: the reason for the relocation, the impact, the parenting time, what that would look like. Has the other person provided notice properly? is there a court order or an agreement that discusses anything with respect to relocation? Is it reasonable? And also, have the parents been complying with the agreement so far, right? So if there has been an agreement, but one of the parents really hasn't been exercising their access, that may make a difference as well. And this is something that they, again, has added into the Divorce Act that is not in the provincial legislation. If the parents have roughly equal parenting time with the kid or the children, the parent that proposes the relocation, the onus is on them to prove on the balance of probability, so more likely than not, that the move is in the child's best interest. So if they want to move and the other parent has about equal time with the children, the parent who's relocating, they have to do the hard work here. They have to be the one to prove that this is something that's in the best interest of the children. However, if the parent that's planning to relocate has the vast majority of time with the child or children already, then it's on the other parent. Then the other parent has the onus to prove that the move is not going to be in the best interest of the child. So it changes a little bit. So this is where mobility has really quite drastically changed in the Divorce Act. And again, that's under the federal legislation. Any questions about mobility at all?
Okay, we've got a few questions.
Great.
First of all, with regard to access to information, this is the prior section.
Yes.
Is the non-custodial parent privy to living arrangement, especially when there is a protection order?
So it would depend on if there is a court order in place. And again, unfortunately, if it's under provincial or federal legislation. So my understanding, and it depends on how the protection order is worded as well, right? So it depends on a couple of factors there. Many protection orders, do have sort of an impact on that, in which case you'd follow the protection order. They don't necessarily have access to that information.
Okay. Next question, a clarification. Is the new law now such that if a child is born after the couple is separated, is that mother automatically entitled to be the primary care parent and the one who makes all the final decisions?
So that's presumed to be the case. Yes. Under the provincial legislation, not under the federal legislation. So if they were not married, yes, that is the case. If they were married, there's no presumption.
Okay. The next question, if the father's name does not appear on the birth certificate, but both parents live together for around a year, what would be the consequence if the mother relocates with the child without the father's consent?
So you should still, if they've been parenting together and there is a presumption that he is a parent by virtue of having, care of the child, right? Then I would say, although I haven't encountered this situation myself, is that they would have the same obligations to inform. Again, there's the different obligations, whether or not they were married or not, right? Those more specific obligations are with respect to if they are married. But her defense might be if he applies to stop the move or stop the relocation, her defense might be, oh, you're not the parent, but that would be quite a rebuttable argument, because he would then say, well, I've been living and taking care of this child for over a year, and I have been a parent to this child. And so that would be sort of the rebuttal to that. So I think, I'm not sure if that answers your question, but I think really the answer is, yes, she still would have an obligation in my mind, and my understanding of the legislation to provide him with information about the move.
Okay. If you have 50% shared custody but need to move out of province for work, are there agreements where the 50% shared custody is shared over the two provinces?
Yes, absolutely. So there's a bunch of agreements that are made. So, you know, I've seen ones where maybe the child is with one parent for the whole of the summer, every school holiday, you know, is there for over Christmas, and then is with the other parent for, you know, periods of time where there's school. So absolutely, there are really creative agreements that can be made that sort of keep up that, you know, that sort of balance. And that does happen. Yes.
One more question. Can one parent object to the other moving from one area of the city to another if it just means additional travel time?
So, I mean, can you object? Yes, always. Is that going to be, you know, changed because of your objection? Probably not, right? You know, again, unless, you know, the one parent really does not want to do all of that driving and can prove that it's not in the best interest of the child and wants to stop this move, you know, but it also depends on the reason for the move. You know, maybe they can't afford a place in the same area of the city, in which case, what are they going to do, right? A judge can't force them to stay in the same area of the city if they're not able to do so. So it's important to balance those things, but the short answer is probably not. There's, you know, it's probably unlikely that there's going to be a reasonable objection to that.
Okay, I don't see any more questions unless none are popping up.
Great.
Thank you.
Oh, that's all good. Thank you for reading them out to me. This is perfect. We're relatively close to the end, so if everyone does want to sort of gather up whatever questions they might have, as I kind of go through our last slide here, which is some enforcement of these types of orders, or agreements or access and custody. So in the event that one parent is being denied access, which we know does happen, they do have some remedies available to them. So this includes contacting the police for assistance. You know, oftentimes the police will find it easier to respond if there is a court order as opposed to an agreement. So that is, you know, a consideration that they may take into consideration if, you know, police decide to assist or not. They can also seek the court's assistance. So the ability, you know, to enforce a bit of that order or change the parameters of what that access looks like, so that it will be enforced, or potentially holding the other person in contempt of a court order if they continue to frustrate access. There are a lot of factors here. You know, the age of the child and what the child wants really play into this a lot, right? You know, if a child is 2 and the parent is consistently not providing access, you know, that's one thing and that can be enforced. If a child is 16 and just doesn't want to go and the other parent is trying to facilitate it, but I mean, that they can't, you know, sort of make a 16-year-old child do something they don't want to do. So there's differing levels to this, and really depends on the circumstances in terms of actually being able to force the enforcement of an order. Sometimes it is possible and sometimes it's less possible depending on the circumstances. When it comes to a child being taken out of the country, the Hague Convention can provide relief if the country to which the child has been taken has ratified that convention, which not all countries are Hague countries. And so it's important for, you know, if a parent is in this situation where another parent has taken a child to another country, they would want to connect with a lawyer as soon as possible to determine, you know, what can be done and if that country is in fact a Hague country. So in order to locate and take a child, according to the Child Custody Enforcement Act, the court has to be satisfied that there are reasonable and probable grounds for believing that any person is unlawfully withholding a child from a person that's entitled to custody of or access to the child. and that a person who is prohibited by a court order or agreement from removing a child from Manitoba is, in fact, removing that child. And the court, by order, may authorize the apprehension of that child or direct a peace officer or police officer or an agency to apprehend that child. I don't see a ton of this in my practice. I don't practice a lot, in that area, but there is sort of the point of it is that there is legislation out there under relatively extreme circumstances to enforce an order in that way. And with that, we've come to the end of our presentation. If there are any other questions, I can answer them now.
Okay, there are quite a few.
Oh, great.
First of all, if the children refuse to go with a parent during their parenting time, is the other parent in contempt if the parenting time is in a court order?
So, I mean, technically, yes, but that's not something that a court would ever hold you in contempt of in that situation, right? So this is where, the voice of the child report or a family assessment might need to be done, right? So there are assessments that are done by the province, and there are assessments that are done by private agencies, and then there are the voice of the child report. So if a child is absolutely refusing to go with another parent, that is the avenue that you would want to take, is have them talk to a therapist, and then that therapist can then say, this is what the child wants, or what they don't want. And then that court order would ideally be varied to allow for the child's wishes to be considered.
How often is the Child Welfare Act revised, changed? I guess maybe this person's asking when was the last time it was changed, or are there going to be changes pending?
Great question. I don't know the answer to that one. That's something I'd have to look up in terms of when it was last changed. And I do not do child welfare work or child protection work, so I am not as up on all of that.
Okay, fair enough. And if there is a child agreement saying both parents have the right to travel outside Canada with the children, and the father refuses to sign the consent letter for the children traveling abroad, what would mom do?
Well, number one, you bring that separation agreement with you because it says that there, right? It's written in there. So hopefully, if you have any problems at the border, that would occur. Secondly, if you are really concerned and there already is a file in court, you can make a motion that will essentially result in you getting a court order that says, yes, this person can travel outside of the country with this child, right? That is something that you can do if you really anticipate there being issues at the border. Another thing that you can do, right? I mean, sometimes a person refuses to sign a consent letter on their own. Sometimes if you get a lawyer involved and have them send a letter that says, look, you have to do this, you put it in the separation agreement that you would sign a consent letter. Sometimes that helps move the issue forward. So those are some options that they can proceed, but they, at the very least, can bring their separation agreement with them, which says that they have the ability to travel.
Okay. When custody has been agreed upon, and now access is being denied to the mother by the father, what should be the mother's next step?
Well, I mean, it depends on the reasons that access is being denied, right? So in this case, if there is an agreement in place and there's no court order, the first step would be to determine, is it possible to change the order? So, change the agreement to reflect the current access arrangements, or to have more stipulations to encourage that access be followed, right? If the access is being denied because of a child's wishes or a child's refusal, this is where you go back to, let's get an assessment. Let's get a therapist involved to see what the issue is, and then kind of move on from there. If it is being denied for a no reason, and it is simply happening, obviously they can always go to court to get a court order that codifies all of this instead of in an agreement.
Okay. Is the Hague Convention applicable to cases where there's no final order or no parenting agreement?
Yes, as long as you're a parent.
And is the Hague Convention applicable to cases where there is no final order or no parenting agreement? Oh, example, parents have separated with the other parent. I guess we've answered that, sorry. And one more. If there is not a child agreement yet and mom has concerns about children's safety, if they're going with their father, could mom face consequences for not allowing the children to see the father?
If there's no agreement, and she consequences is tough because can one parent kind of characterize it negatively to either a lawyer or to a judge? Yes, that is possible, but she's not under any obligation, and she should be acting in the best interest of the child. So if she is concerned, there's no agreement, there's no court order, she absolutely can say, nope, this is my concern. I don't want this kind of access or this kind of parenting time from you. So yes, short answer, yes.